I've had a few people talk to me about the Leon Valley defendants subpoenaing documents from Google. It's not a warrant, it's a subpoena. This is Rule 176 of the Texas Code of Civil Procedure. I'm not super familiar with the Texas Code of Civil Procedure, obviously, because I am not a Texas attorney, but it seems to be pretty much in line with what California is doing. So I'm going to apply some of my California understanding to what Texas is doing. There, if you request a if you notify somebody, if you serve them with a subpoena, then they have to appear or produce documents. If they don't, then they can be held in contempt. There are two basic ways to prevent or stop the subpoena from happening or a portion of it from happening, etc. There are objections and there are protective orders. I'm not sure entirely of what the difference is. In California, it doesn't quite work this way. From my understanding, just reading this, an objection would be something that your attorney would serve on the other party, saying that you're objecting to the production of various things. And then the party requesting the subpoena can go to court, get a motion to compel, and then if they get the motion to compel, you have to produce the documents or produce the testimony. If they don't get the motion to compel, then you don't. You probably still have to turn up. Protective orders are a little broader, apparently. A protective order is essentially the same thing, except instead of notifying the other party, serving the other party with an objection, you would actually file a motion in a court. You'd still have to serve the other party with it, but you'd file a motion. You'd be asking for the court to make a determination that you don't have to give these particular documents or this particular testimony. And maybe you don't even have to show up at all. If you can prove to the court that they're doing it in bad faith, they're just trying to harass you, it doesn't have any actual evidentiary value, it's protected product like attorney-client privilege, or it's work product that was prepared in anticipation of litigation, or they're trying to get you to appear more than 150 miles away from where you live, etc. There are various reasons why you can get a protective order. And again, if the party requesting the subpoena wants to basically try to overcome that, then again, they'd have to motion to court, a motion to compel. If the court grants it, then you still have to show up and produce whatever documents you're compelled to produce. Nowhere in here, you may notice, does it say that you can just email Google back and say, hey, I really don't want you to give them my emails or my videos. It doesn't work that way. The proper response, if you get something from Google saying that they've been subpoenaed to produce your documents, then what you do is you go to your attorney and you say, hey, look, this is what's going on. How do we want to deal with it? Or do you already have plans? Because if you may notice, objections need to be served on the opposing party, which means that your attorney probably received the objection or probably received the subpoena. I'm sorry. So the subpoena would have to be noticed. Opposing counsel would get a copy of the subpoena. If the opposing counsel wants to object to it, then opposing counsel would have to serve the objection, and he would probably send a copy to Google and to the opposing party, as well as file it at the court. Protective orders are going to be the same way. He's going to file the motion at the court and serve opposing counsel and Google. So everybody knows what's going on. All the parties are aware that your attorney isn't telling you what's going on. That could be something you may wish to talk to your attorney about, because if your attorney receives something like this, your attorney should be passing it along to you, as well as telling you what the attorney believes the best plan of action is, if he has one at the time. So yeah, if you get an email from Google saying that your records have been the subject of a subpoena, then you talk to your attorney, find out what your attorney is doing or wants to do or plans on doing, and that would involve either an objection, a protective order, or him just saying, well, we're going to save money, let them get the documents because we don't actually have a valid objection or a valid protective order, and we would just be wasting your time or your money and my time by trying to fight this. Anyway, so not really terribly interesting. I don't know why the defense counsel is doing it. I would guess either they're looking for something specific, like content that was deleted from YouTube, comments that were deleted from YouTube, videos that were deleted from YouTube, something that might be used in their defense, or it's just a general kind of dragnet sort of thing. All of this action was tied up heavily with YouTube, with Google, and so they're casting a dragnet trying to look for something that they could cobble together to create a defense to show that there was probable cause for the officers to do what they were doing based on these things that are on Google and YouTube, etc. Anyway, I hope that answers your question, Timon0x31. Thank you for watching and have a great day.